Good afternoon. Hello. Oh, good afternoon. Welcome to Milwaukee Bar Association. Thanks everybody for coming. I'm Sarah Martis. I'm the executive director of the bar, so we're so happy to have everyone here in our new facility. If you haven't been here yet, welcome. Please know that this facility is for your use, so if you want to come work here, you absolutely can have meetings, meet clients, pretty much anything. So, and much of it for free. And if not, for stupidly low prices compared to everything else in the city, because we looked. So please do use it. We've law students come study here, so it can really be used for anything for the legal community. But today we're here to talk about the rise and fall of CBD in Wisconsin, the pitfalls and the considerations. And here to talk with us about it is Emil Oviagele and Jason Luzak. So welcome. Thank you so much for being here.
Thank you.
And off we go. Thanks.
All right. Well, this is how we're going to you've seen the outline, and here's how we're going to break this up. My background is mostly in criminal defense, so I've taken a look at the way that CBD has been developed and how it's changing and kind of the legal landscape of growing, possessing, other things, and whether it is or is not legal, and whether it can subject you to some sort of criminal liability. Emil is mostly focused on the business aspect of things, the drafting of contracts and things like that, to make sure that you're allocating risks and you're taking into account the various regulations. Because right now, basically it's not completely Wild West, but it's pretty close. And there's going to be some things that are still developing in the law. And basically what you have with the CBD industry is an industry that is up and running, and having to basically deal with both federal regulations and the unscheduling of industrial hemp, which has occurred, which is important. We'll kind of explain why. And then also the pilot program that was adopted by Wisconsin and some of the immunities and protections that provides for people who are producing, growing, and processing hemp-derived products, which CBD is a hemp-derived product. So in order to kind of get the nomenclature correct of what we're talking about here, cannabis, as we're talking about it, could be divided into three types, but the two that we're going to be most interested in today are cannabis sativa and then cannabis indica. Indica is what we would refer to as marijuana. And sativa is basically what has been identified and is hemp. They share some common properties, obviously, but the key thing as it relates to CBD is that sativa is very high in CBD and it should be lower in THC. THC is very high in indica, and that's what we commonly refer to as marijuana. So you'll see it's a shorter plant, it's leafier, it contains a much higher level of THC. So what the 2018 Farm Bill did was basically marijuana and all products, including hemp, were Schedule I controlled substance. And that's obviously very important because that makes it illegal to possess and really in process or do anything with. And so what the 2018 Farm Bill did on a federal level is it took cannabis sativa and basically removed it from the Schedule I Controlled Substances Act. In response to that, Wisconsin adopted an industrial hemp program. Basically, and Emil will kind of explain how that operates because it has certain requirements. But the important thing to note is that Wisconsin has adopted a pilot program, and there's currently what they're calling a Hemp 2.0 bill to make that pilot program permanent. So, Emil, if you could kind of explain how the actual pilot program works from a business perspective, because there's obviously certain requirements that have to be followed in order to ensure that you're in compliance with the law. And the important thing here is that you're dealing with a product that has THC in it. And the likelihood of having THC in it. If the THC level gets to a high enough level, then you are potentially in violation of the law. But the law allows for certain protections, but there are a lot of risks associated with it because you have to destroy that product because of the high level of THC. So, Emil, if you can kind of explain how the pilot program actually works.
Yeah, sure. So Wisconsin's pilot program was created under the 2014 Farm Bill, actually, which authorized states to set up these research pilot programs that would allow growers and processors produce and process hemp under certain guidelines. In response to that, in 2017, I think sometime in December, Act 100 was passed into law, which authorized the Wisconsin pilot program as we know it today. And under that program, it became legal to produce and grow hemp as long as it was being done in connection with some sort of research purpose. What the bona fide research purpose could be and the extent of it, we're quite lax. And I think during the first year, there were about 245 grower applications and about 100 processor applications. I think out of the 200, over 200 applications for growers, about 150 farmers actually planted crops. And the whole idea was the whole idea of the 2014 Farm Bill was to give states and producers some sort of leeway to research or to be able to produce this crop for research purposes and marketing purposes, just as a first step. Now, in 2018, the 2018 Farm Bill was passed by Congress. Now, it's very significant because first, it makes a lot of the aspirations of having a legal framework for hemp permanent by declassifying hemp from the CSA, the Controlled Substances Act, making it legal as defined here today, and also giving states now two options, either the option A of coming up with their own program for licensing and governing their own hemp programs within their state, but also giving other growers who may be in a state where there isn't an appetite for that stuff, a secondary option under the U.S. Department of Agriculture's plan. To date, I don't think any state has submitted their plans to the U.S. Department of Agriculture. I know Wisconsin, we're currently in the process of doing that. That's what the hemp 2.0, I guess, is the name they're calling it out in Madison, is supposed to do. And also importantly, the 2018 Farm Bill answered a very important question, which a lot of businesses had, and a lot of people who wanted to possess hemp had. It really cleared up the whole interstate commerce aspect of things. So no longer would the transportation of legally compliant hemp from across state lines become an issue. There was a case, a famous case within the circles from a couple of years ago where you had a driver who was transporting some hemp from a state where it was legal to another state where it was legal, but had to go through. I don't want to offend anyone from if I get the state wrong. I think it was Idaho. I can't remember. It was Idaho. There we go. All right. So sorry. And got arrested. And because in Idaho, hemp, they didn't have a pilot program and it was illegal. So the 2018 Farm Bill is supposed to set the framework for a more permanent system to come into being, either as regulated by states or by the federal government. But one thing's clear. States can't have direct prohibitions that would frustrate the purposes of the 2014 Farm Bills. Now, they could still do some regulations, as with most things, but if the regulations seen to frustrate the purposes of the 2018 Farm Bill, I suppose some fancy constitutional and federal court lawyers would probably step in and try to challenge those laws on supremacy grounds. So that's kind of where we're at right now. And another important aspect of the 2018 Farm Bill is it also expresses an intent for the FDA or for some sort of other government regulatory agency to come up with some sort of regulatory framework for secondary products. And I think that's where a lot of the confusion would be, currently lies, because there is no regulatory framework, and most people see CBD, at least on the consumer side, based on the things they see on the shelves. What that looks like right now is still very unclear. Just to demonstrate how fast moving this industry has been, as of last Thursday, the Senate and the House of Representatives sent a letter to the FDA asking them to kind of speed up their timetable because you have these products out there. But the important thing about the letter to the FDA was asking them to actually come up with a framework wherein legal goods or legal secondary products can be authorized or denoted as being legal. So kind of telling them in uncertain terms that after the 120 days, we want some sort of system wherein some of the goods that are currently being sold can be deemed legal. But again, it's a fast-moving industry, as most of you do know. The law constantly changes. The regulations trying to catch up to the reality of things. And hopefully we can kind of clear things up. But the 2018 Farm Bill sets this entire thing up in terms of what happens next.
All right, so looking at it now back to a criminal perspective, if you have someone who has come in and is asking you, what activities are going to subject me to the potential of criminal liability, the law has what I would call certain spheres of legality. So under Chapter 94, which lays out the pilot program, there's certain very clear things that someone who has a license, who has applied for a license, can do, which includes, the growing, the transporting, the processing type activities. But obviously, that runs into the aspect of, okay, once you have this product that's made, once you have CBD, what can you do with it? The 2018 Farm Bill makes it clear that the transporting of that within interstate commerce cannot be affected by any sort of state law. So when you're looking at the actual, under the Wisconsin statutes, if somebody, a consumer, actually is possessing this thing, possessing CBD, it presents some interesting questions, because when you look at the actual Controlled Substances Act under Wisconsin, THC is clearly still a Schedule I controlled substance, which is prohibited from being possessed. So if you go along and you look at the statutes, because basically it seems as though the statutes have obviously not caught up to the reality of the situation. CBD oil is everywhere. It's in grocery stores. People are possessing it, thinking that it is legal, and law enforcement has taken the approach that there's not going to be any sort of enforcement action right now because of the confusion in the law. And when you look at the actual possession authorization statute, which basically allows for, and this was Governor Walker signed this in 2017, this was the bill, CBD oil has properties which we won't really discuss, but has certain properties that are very helpful, at least anecdotally, and some clinical studies have shown, in relation to seizure disorders. So the purpose of the possession authorization statute allowed for the possession of CBD oil with a certain certification, which is under 961.32 of the statutes. And that provided certain requirements. You needed to have a physician's note basically certifying that you had a medical need to possess CBD oil. So that obviously provides some sort of immunity or some level of protection from a criminal prosecution standpoint. But as we know, and as you can just see, there's not many people going around getting certification letters from doctors to possess CBD oil. So then you look further in the statutes to see that under sub 3 of that same section, under 961.32, under sub 3B, it says that a person who is acting in accordance with the rules promulgated by DATCAP in relation to the industrial hemp program, and it basically lays out certain things that if you're possessing it as a part of the industrial hemp program, you can't be prosecuted. And then they add another layer of protection there under sub C, where they talk about that law enforcement doesn't even really have the right to do anything as far as reporting or referring a case in violation of the industrial hemp program, that specific authority lies with DATCAP. So DATCAP, who's taken a position that that the products derived from industrial hemp are legal, would have to be the one to refer the case to the district attorney's office in the county where the alleged violation occurred. So if you're looking at it though from a consumer perspective, the question becomes, is a consumer who goes to the grocery stores and buys CBD oil a person who is acting in accordance with the rules promulgated under the industrial hemp pilot program?
Jason, just on that point, with the current legislation being considered over in Madison, there's a specific amendment, at least it's been proposed to that portion of the law. How does that square up with what it used to be?
So
So
the Hemp 2.0 bill, under the current, I think it's vague whether, and I think there's strong arguments to say that a person just possessing as a consumer is acting under the rules promulgated under the industrial hemp program, which lays out certain requirements for them to do. But the Hemp 2.0 bill basically changes things because, and it actually is somewhat of it's an interesting way of kind of changing the statute. Instead of saying a person under the coverage of the source immunity, which I'll call it, instead of saying that it's a person acting in accordance with the rules, it would change it to say a person who is not otherwise violating the Industrial Hemp Act, which could include everybody. I mean, I'm not going around violating the Industrial Hemp Act if I'm going and buying CBD oil, which I think is the legislature's way or the Senate's way, and obviously this is not passed yet, but it would be a way to provide greater protections when you're trying to advise somebody about the legalities of possession of CBD oil, because right now it's very unclear. Some of the other problems that you have, and Emil can kind of explain this from the business side, is what occurs, Emil, if you are a grower and you're acting under the industrial hemp program and your product is tested and it has a THC level higher than what the legal limit is?
Currently, under the current statutory framework for the pilot program, farmers have 30 days. They must notify DATCAP within 30 days prior to harvesting. After that notification takes place, DATCAP would usually send some employees of theirs to take samples of the various crops you have. If you have different varieties, they try to take a sampling of the varieties as well. Now, I think it takes about, from my experience, about a week or two for the results to come back in. And if it comes back higher than 0.3, you have two options. You can either ask for it to be retested, or you could have it destroyed. And you actually have to destroy it, I think, within a certain amount of time. And I'm not a chemist, but from my understanding, it could be hemp in and of itself could be quite volatile depending on the types of seeds you use. And it's one of those things where I think the longer and the older it gets, the higher the THC content might actually become. So from a business standpoint, and we could talk about this later on, if you are a distributor who's invested or you're under an agricultural contract, production contract with a grower, and you're expecting a lot from that contract, and then the test results come out, and all of a sudden everything has to be destroyed, and your whole business model or your business structure was based off of that, expecting those crops to come through, that could put your client in a very, very weird position. But yeah, so right now the options are if it comes back higher than 0.3, it has to be destroyed, or you have the option to have it retested. But in my experience, and I've had clients who've had crops test at higher levels, the retesting usually doesn't help. I mean, they're often if you have like what comes like a 0.6, I doubt retesting it makes it lower. But if you're kind of on the margins and all of that stuff, in instances like that, it helps. I mean, my experience is I've had it either way lower, or clients have had it maybe a little bit more, and in the latter, most times they have to destroy the crop within 10 days.
Yeah.
Quick question on that.
Yes.
And sorry, I may have missed that. Under what testing standards? Is there a standard testing protocol or set of standards that USDA is supposed to come out at some point with as a federal testing standard? So for purposes of Wisconsin,
I'm just going to repeat the question because it's being recorded. So you're asking what testing standards are currently used. There is a testing standard the DACCAP does use, but it's as for whether or not it's uniform, that's something that's still left to be seen. I believe currently, I was just finding they actually have the expressed standards used. As part of their, there's an admin code that deals with this specifically, and the method used is called high performance liquid chromatography, or HPLC, and they test for delta 9 total THC using a formula. There's a formula on there that chemists, I'm sure, could appreciate. But there is a formula stated, and I think it's based on a dry weight basis. But these are also things that are going to continue to evolve, because I know the testing industry is now a big thing, and you have secondary or equipment providers saying, hey, this equipment does it best. We should probably use this standard over that standard. What standards we eventually go with, that's something that I think industry leaders are going to have to decide, or in collaboration with DACCAP.
And one of the problems with testing, this brings up another criminal aspect, is that, and I guess I'll pretend to be a chemist here, okay? So CBD and THC have they're isomers, meaning that they have the exact same chemical makeup and weight, but there's one bond that's different between CBD and THC. And apparently, the bond, or CBD, is more volatile than THC. So there can be times, and this brings up some interesting criminal potential liability, because you could have a CBD oil that basically could convert from being CBD to having a higher amount of THC. So if you get pulled over and law enforcement sees that you have CBD oil and they test it, it'll likely test positive under any scenario for THC or marijuana. But then the question becomes, at what level is it? And then how do you prove that the source of your CBD is industrial hemp? Now, obviously, your possession has to be knowing. So, but if you're advising clients to be as safe as possible, I mean, you're bringing up very questionable issues where, how do you prove? And that is kind of where we are in the standpoint of it being a bit of the Wild West. And I think that that's why, yes, go ahead.
Yeah, I've kind of researched quite a bit of this, but there's a difference. I think it's delta 9 and there's a delta 7 or something like that. And I need to get to the bottom of this, because I was told by one of our state senators that the laws for federal for the THC amount is the same for Wisconsin, but DACCAP doesn't do that. So I can't remember, but federal will only pick up one of them, the delta 9.
I think it's delta 9, yes.
But the state of Wisconsin picks up both of them, adds it together, and it puts a lot of people through the roof,
Yeah, so that's interesting. So just for people who are watching, so one of the people in the audience have had an issue where delta 7 and delta 9 seem to be tested and combined in the Wisconsin test, and they're not in the federal law, which obviously presents a serious issue as far as the risks associated too from a business perspective, because if it tests too high, you have to destroy the product, otherwise you're in violation. Now, Emil, if I am operating or I want to start a hemp growing operation, and I want to have insurance, crop insurance, can I do that? And is that available right now?
It technically should be, but right now it's not. The whole idea is, if you think about the Farm Bill, it really doesn't go into effect till next year in a way. So what happens is, certain aspects of it in terms of the program. So states, I think, have till the end of the year, early next year, to come up with their own programs, and the United States Department of Agriculture is going to fill in the gaps. But in the meantime, we have these hemp programs that we have to that our businesses have to comply with until the United States Department of Agriculture at least creates an alternative for other people. At least in Wisconsin, we have something. We have something that businesses have to follow. On the testing, though, I will point out that according to DATCAP, they do follow the 2018 Farm Bill's testing provision, which requires some sort of, which is supposed to test for Delta 9 and requires some sort of I think it's called decarbonization. I think so. That's a technical term. But basically, your testing method, in order for it to be approved by the U.S. Department of Agriculture, has to be one of those as espoused under the 2018 Farm Bill. So that's kind of where we stand today. I mean, I would say, at least when I advise businesses, and things still haven't changed in terms of getting your licenses. You get your licenses under the Industrial Farm, Wisconsin's Act 100, and because Act 100 authorizes DATCAP to come up with rules, emergency rules for now. I call them a lot, just to ask some basic questions, because on some level we are making this up as we go until there is a law or program that conforms to the 2018 Farm Bill. There is a lot of leeway within the administration and enforcement in some of these statutes, or at least this law for now, as it relates to businesses and their operations.
Yeah, so getting to kind of getting back on track with the outline here. So, some of the other considerations that we have from a criminal perspective, which I kind of outline in the hypotheticals that I provided, is that let's say you have a client that's arrested for OWI and blood reveals a small amount of THC. And the client says that it was from usage of CBD oil, and this seems to be a common defense nowadays, is that a lot of people are using CBD oil and it's appearing as THC. Now, it's because the testing is not as regulated as it probably should be as it relates to the end user product. There just anecdotally are apparently some products that have tested and do test high in THC. So it could be a legitimate argument, but OWI law in Wisconsin is that it's basically a strict liability offense. So if you have 1 nanogram, which is 1 part per billion of THC that shows up in your blood test, you can be held liable for an OWI. And the Hemp 2.0 bill, and this was kind of the politics behind this. So the Hemp 2.0 bill would have added as an affirmative defense THC if you have a state certification. So you could have argued that, well, like a prescription drug, I have it in my system. It's not intoxicating, and therefore I should not be held liable or found guilty of an OWI. But in order to get law enforcement on board, because there was a big concern that THC levels, there would be too much probably litigation about whether the person had THC in their system based on a prescription, or they removed that from Hemp 2.0. So that's been crossed out. So the THC defense in relation to that has been taken out. So the question becomes at what point, and if you're using as a consumer, at what point in time can you drive after taking CBD oil? I guess it depends on whether it has THC in it. And it's hard because most of the products say they don't contain any THC, but as we know, the CBD can change into THC, or there can be a certain acceptable level of THC. And it seems as though, based on some of the testing, that people can have, if they use CBD oil a lot, you can have a base level of THC in your system driving around. And if you're pulled over, there's a potential that, because it's a strict liability offense, that if you have that 1 nanogram in your bloodstream, that you could be at risk of having an OWI. Some of the other areas where we've dealt with this in the criminal law are judges or court commissioners imposing bail conditions in relation to not using CBD oil while you're on bail. And one of the, you can certainly argue against it because of the fact that it's not psychoactive, but the basis seems to be that if you are being tested regularly, if you're having to take urine tests as part of your bail conditions, it can affect, obviously, the test, because you don't know if somebody has a level of THC in their system because they've been using CBD oil or they've been using marijuana. So a lot of these things have to be obviously worked out, and if you have somebody who is, let's say, in the criminal justice system already, you have to be very acutely aware of them, because you could be unknowingly putting yourself at risk. I mean, just as mouthwash can affect certain if you're taking, let's say, Robitussin, that can affect certain things that are in your blood or your urine that can show up as controlled substances that can obviously create issues for your clients. The other interesting aspect of this, and where the law may be kind of shifting, is in relation to Fourth Amendment law as it relates to probable cause, reasonable suspicion. So there have been some reports that industrial hemp smells just like marijuana when burned. And so there's, I have the case in here in the outline, State versus Sechrist, which involved someone being pulled over. They smelled an odor of marijuana. And basically the court essentially said, the unmistakable odor of marijuana coming from an automobile provides probable cause for an officer to believe that the automobile contains evidence of a crime. Well, if you have legalized industrial hemp products out there and they look and smell just like an illegal drug, well, does that give you probable cause? Likely, my guess is that the courts would probably say it still gives you reasonable suspicion to investigate a crime, because obviously if you're smelling an odor, I mean, there's any number of things where the law says that, there can either be an innocent explanation or there can be something suspicious going on. There is a case, State versus Waldner, where a guy is sitting in his car and he's drinking a root beer, which looks like a beer bottle. And they pulled him over and they found that even though it was innocent conduct, they found it to be suspicious because it looked like a beer bottle. So they could use that same type of idea to probably find that the law doesn't change much in relation. But these are a lot of the considerations that we have, which the public is not really aware of. And it's kind of, it's akin to, I think, what I'll call the grocery store rule. If you can buy something in the grocery store, you probably think it's legal, right? And it's not something that's going to get you in trouble. And that's not necessarily true. And I think as lawyers advising people in this area, particularly, I think the criminal defense bar is actually leaning more towards being a little bit more conservative in relation to the advice that we give clients who are, the subject of higher scrutiny through bail conditions and court monitoring activities, because something that everyone seems to be doing, or it's widely available, is something that can put them acutely at risk. So
That kind of reminds me of, there's a case out, I think it was out west as well. Lots of things happen out west on these things, but where you had a driver, a truck driver, who had some back spasms or some back pain, and went to one of these stores and got a CBD product, and specifically the product, the oil said it had 0% THC because having, as a truck driver, any level of THC leads to one losing your license, a semi-truck driver. And so this for CDL purposes. So the individual gets tested, and obviously there was a higher level of THC in his blood content, and ended up losing, I think, his CDL license. So the driver does something quite interesting. I think he goes back to the store and buys a bunch of these oils and gets them tested. And I think a lot of them had higher levels of THC when they represented that they had none. And I think that led to a RICO action and misrepresentation claims and a bunch of other things. And so that I think that to go to Jason's point, that's one of those strict liability situations. But also on the civil side of things, especially when, as you advise clients on these things, making certain types of claims could potentially open them up to liability, especially since there's so many. I mean, in my experience, by the time it gets to most retailers, there's so many people who've touched the good, from the grower to the processor. Now you have distributors. Now you have brand houses. And ultimately gets to the retailer and then the consumer. And when we go into, I don't know if we're talking about the broader business considerations, making sure, at least on a retail side or wherever your client fits into the supply chain, making sure that they can source these things and they're getting accurate documentation just to protect themselves from a risk perspective becomes very, very important. Knowing where the goods have been and potentially where they're going to, just to sort of avoid these things. Because again, it is the wild, wild west. Crazy claims are being made. I think a lot of things that are out there aren't what they say they are. But right now, there's just so much being thrown at the government that a lot of these actors are kind of just flying under the radar. But as lawyers, it's still important for us to be aware of these things and caution our clients accordingly. And I have a couple of ideas on how to do that from a deal structure and standpoint. But I don't know if there's any other things you want to talk about.
Yeah. So I guess the only other aspect of and this is kind of addressing the outline. So if I had someone who was being subjected to any sort of criminal liability for something that they did in relation to possessing CBD oil, I think that there would definitely be a number of constitutional claims that you could make, because if you are a normal person, I think there's a lack of fair notice about what's illegal in the statutes. I think you can spend days parsing out the language here, and it's not clear, and the industrial hemp program has a certain layer of protection that seems to be given to certain individuals that's not necessarily clear, and it presents a question of, so they're able to possess, they're able to produce, they're able to grow, but the product then is illegal. I mean, that seems to be something that doesn't really make sense and would be subject to an equal protection claim, a due process argument as to the vagueness and the ambiguity that's in the statutes. So I think that for right now, everyone's just kind of holding still and there's not much in the way of enforcement, but I think that if there is, with the state of the law as it is right now, which I think Hemp 2.0 is trying to clarify it, and make those protections, the immunity, more clear. But until then, I think if everyone's holding at bay, everyone's going to be buying this stuff, and it's going to be, unregulated. But once it starts getting more regulated, there's going to be more by way of, I think, challenges to any sort of enforcement action. So, Emil, as far as the broader considerations for businesses, what are those in relation to CBD?
Yeah, before I talk about that, just give you a little background. So I consider myself a transactional attorney with a litigator's outlook. About 65% of what I do is transaction, putting deals together, and the other percentage, I'm litigating most times the deals I'm putting together. So I do a lot of commercial transactions, and so it kind of gives me a unique perspective in the sense that I get to see things from the deal perspective, and I get to see how they play out when they blow up. And with advising my clients in this space, I do represent a couple of growers and some retailers. I try to have that litigation consideration at the back of my mind, but not just in terms of hypothetical risk, but in terms of the real risk, which we are seeing and which we will continue to see as this industry grows. First, it can't be stressed enough. Regardless of where, if you're advising clients who fall into any of the spectrums on the supply chain, they must have comprehensive contracts. And not just, and the thing about it, don't get me wrong, at the end of the day, it may be a new industry, but the same risks sort of do apply. You're still drafting a contract. But in this circumstance, you have to kind of detail some things that we normally think are kind of great. For instance, or we would not normally have to detail in a regular distribution contract. Even things like in the recitals, just reciting where the product has been, the fact that, let's say if you're representing a processor, the fact that the manufacturer gave you their fit for commerce certificate, that they have a licensing number, you reviewed that and all of that stuff. Because the way I think about it is, in the event that you're faced with either a compliance review or compliance audit or some sort of third-party litigation or even criminal consideration, you can document the fact that you did your due diligence, not just by saying we did it, but actually showing a document that says, hey, no, we asked for it, we put it in our contract, and all of that stuff. So comprehensive written agreements cannot be stressed enough. Things like payment terms. Now, the type of terms that would matter would depend on what the nature of the relationship. Now, between a manufacturer and a processor, you're probably going to have different relationships or different terms that would mean more to you as compared to a processor and a distributor or a retailer. But the key ones or the more difficult contracts to draft are the ones between manufacturers and the distributors or the processors, because that's where the highest level of risk and unpredictability lies. For instance, a lot of producers are probably in the process of testing after the season right now. And there are a lot of distribution contracts that have already been drafted where you have distributors, large and small, relying on the produce or the yields of these growers. How do you account for a situation where the entire batch has to be destroyed? Who bears that risk? At what point does title pass from a grower to a processor? Maybe looking into your force majeure clauses and not just doing them as those form things and expanding upon them, that may be an angle, a way to tackle some of these risks. Taking a deeper look into those things. Maybe advising your client, if you're on the distribution side, to probably contract with multiple growers just to hedge that risk. As a business attorney, I just don't believe in drafting contracts. I believe that we also serve a role in advising our clients on some practical business considerations. Because if you think about risk, it's not just all legal. I guess the legal ties in with the business as well. So practical things like that become very important to consider. In an avenue where there still really isn't crop insurance, and I think once that becomes a thing, some of these from the production side may be taken care of. But for now, we're going to have to contend with that. The representation clauses become very important in these types of contracts. Making sure that you're tying the grower or the processor, that they're representing, that they're giving you a legally compliant product. And then you also have issues of delays caused by the wrong cop on the wrong day in the wrong state pulling over a truck driver, and what that does, like who bears that risk when that occurs. It becomes very, very important to detail the relationship of the parties. I would also, for now, advise that, especially with CBD companies, that the choice of law provision may also be very important. Maybe not as much because now it's now federally regulated, but before the 2018 Farm Bill, the choice of law provision was very, very important, making sure that, you know, the laws or the contracts were being governed by a state where at least it was recognized. That's going to be less of a consideration right now because of the 2018 Farm Bill. But it can't be stressed enough. Form contracts will not do when it comes to this avenue, when it comes to this fair. And as lawyers, I think we also need to understand our clients, the parties on the other side, and also the nature of their business to be able to add that type of value. Second would be the source and legal products. You know, again, it's clear if it's not grown according to a pilot program according to law under the 2018 Farm Bill, it taints the product from the very source. So even if you're a retailer and you get a product that wasn't grown by a grower in accordance to the law, you are in possession of an illegal good. So as lawyers, how to trace the traceability of the product becomes even more important, not just from a contractual consideration, but from a practical due diligence consideration standpoint. You know, advising your clients. If you're buying from a distributor, you want to see who their processor was and know who the processor was from a title standpoint, and you want to know who the grower was, what program they complied with, their fit for commerce certificates, their license numbers. Again, if the product is tainted at any point during the supply chain, the product is illegal, and that opens up your client, wherever they may be on the supply chain, to liability considerations. Making sure that what they're purchasing, again, isn't marijuana. That goes without being said. But it's also, the reason Jason has started with this nomenclature is because there's been a lot of confusion with, with hemp, marijuana, CBD, and all that stuff. Whatever you choose to call it in the contracts or in the deals that you are, just make sure it complies with the laws as they require them to be. There will also be certain local considerations. Now, Wisconsin, I don't think there are any municipalities that have passed any special regulations. Right now, as it stands, retailers don't need a license. They don't need any specialized license to sell CBD products. Now, obviously, if you're selling something that can be vaped or smoked, you're probably going to need some sort of tobacco, or in conjunction with tobacco license. But general zoning laws and municipal laws, as it relates to the entity or the type of business, do apply. But there aren't any specific ordinances related to CBD. Now, if Washington or if California is anything to go by, where you had a massive reaction by certain municipalities in terms of trying to just squeeze out businesses of this nature out of that, I expect that it would, in the upcoming future, we're probably going to see more reaction at the local level. But again, businesses still have to comply with general things like occupancy and all of that stuff. I've also had situations where a retail operation is trying to open up in a city where they may not be as familiar with it. And I'll tell you this, sending a bunch of laws to them and legal analysis to the alderperson or whatever, or the common council, probably wouldn't make as much of a difference as going down there and just kind of sitting down and explaining things to them and saying, hey, my client's selling something that's legal, here are the laws that they have to follow, here are the fit for commerce certificates and all that stuff. Because a lot of people just don't know. It's still a learning experience, even for us as lawyers. And so I found that practical approach with dealing with local authorities to be very, very helpful. Chain of custody considerations, very, very important. Like I said, get all of that information in the contract if possible, just to trace it. Let the contract read as a narrative of where the product has been and where it's going to. On the retail side of things, and for the brand people out there, I expect to see much more branding deals. I mean, I think on the marijuana side, you have famous people like Snoop Dogg and artists and other sports, maybe not sports people yet, retired sports people, lending their names and to these things. So if you're representing a client who's going to be doing some sort of branding or having their brand associated with a product, making sure that what's posted out there or what that product says is real. Right now, I just tell people less is more. It's THC oil, or sorry, not THC oil. It's CBD oil, not THC oil. It's CBD oil. This is the name of it. This is where it comes from. This is our fit for certificate. These are the contents, and that's it. I mean, I know most marketing people, they don't like that. They try to stretch it. I mean, I think going up to Green Bay, there is a big sign that I think violates the current FDA standards or FTC standards for advertising, making certain claims about, health claims and stuff. So less is more, no health claims until it's certified. Yes, we don't have a process for that. The FDA is still catching up, but the position right now by the FDA is making health claims that have not been verified by them. It's just illegal. In Wisconsin, we follow. We don't have our own. We don't have our equivalent of the FDA. I think it falls under the Department of Agriculture, but we kind of subscribe to. We do subscribe to the FDA's warning and rules on these things. So less is more. No health claims or crazy claims. I've seen some crazy claims. Definitely open up your clients to a bunch of third-party, and not just federal prosecution or state prosecution, but also third-party concerns. And I think products liability lawyers are going to be very busy very soon because, again, there are crazy claims out there. So advise clients not to do that. But here's another thing too: if you're involved if you're a producer, for instance, lending your brand to some sort of brand house, making sure that you're advising your clients to put in the contract that they can't make any claims that they don't verify becomes very, very important, right? Just to make, and they're not doing it not just on the product itself, but online and on Facebook. I expect the FTC to get involved in this space as well pretty soon. I know Facebook, they try to get these things out, but every now and then a couple of these ads still make it through. But by and large, as a growing industry and as a newer industry, I think clients in the business sphere are going to require a whole lot of hand-holding, especially with something that requires a lot of, that really borders on some criminality. I don't do criminal law, so I do recommend a lot of questions to Jason. As if you're a business attorney, I would suggest having another criminal defense attorney as part of your client's team, just because when those questions arise, you want them to be able to have a secondary opinion on those criminal considerations as they are. Not just because it's a prudent thing to do, also from liability perspectives for us lawyers. Don't want your client saying, hey, I went to jail because you told me everything I was doing was right. Obviously, always hedge because it is a fast-moving industry. Play it safe, be safer. We're lawyers. I like to give safer advice, and the extreme of being conservative. I mean, that's my role on a team of businesses. They can take it and do with it what they want, but we are going to be shepherding our clients as being seen as Sherpas throughout this process. And I can't stress putting our ears down and listening to the trends as they change, because it's a fast-moving industry. Things are changing almost on a weekly basis. So those are some considerations.
All right, any questions? We've got about 5 minutes. Yeah.
Getting to like the criminal side, how long does THC stay in the blood versus the urine? Is it longer?
Okay, so the question is, how long does THC stay in the blood versus the urine?
Yeah, so like, yeah, go ahead.
Yeah, I mean, THC breaks down. If there's delta-9 THC, that will show up, and it will end up breaking down. There's kind of, I forget the other, it breaks down into a different compound, which is also shown. But I think that the urine, I think it passes through your urine quicker than the blood. but.
I want just some clarity on the issue from my mind, the Farm Bill, with respect to production and transportation and sale across state lines. So I think I'm clear on the fact that if you have a local producer here selling in Wisconsin a derivative of hemp, that's fine, that's kosher, especially if they're part of the program, the pilot program. But then, let's say they go and they sell it next door, and they cross that state line. They produce it, they get the CBD, they cross state line, and let's say they cross into a state line, or they send it through the mail, right, to somewhere that doesn't allow for the sale or use of CBD. Is it your understanding that the 2018 Farm Bill kind of does away with all these interstate problems on behalf of the individual who's producing and selling it from any liability under state law, because interstate commerce preempts all of these other state prohibitions? Or does the state still play a role in regulating it? Or does the Fed still play a role, or state play a role in regulating it if you're selling a derivative of a product, for example, in this case, CBD?
Okay, so the question is, if you are in a state where you are, let's say, operating under the pilot program, and you create CBD oil or some sort of derivative of hemp, and then you transfer it through the mail to a state where, let's say, CBD oil is illegal. The feds, and they came out, the USDA, May 28th of 2019, and this is in the interim between the time where Attorney General Schimmel at the time released that opinion saying that CBD oil is illegal in any form, and then there was the outcry, and then there was a kind of a taking back of that opinion. In the interim, the May 28th, Sonny Perdue, the Secretary of Agriculture, came out with certain interpretations of, and one of the outgrowths of that is that no state can put any restrictions that affect interstate commerce. So if you're talking about the liability of the producer, that would probably fall more so under the federal protection. But if you are transferring it to someone who then is, because it didn't say that CBD oil is legal. That really, it did say that Sonny Perdue said in the legal opinion that states can still regulate it. So you would still obviously have to comply with the regulations of the state. But that's where you get into this odd issue of kind of the reverse of the marijuana laws, where federally marijuana is a Schedule I narcotic, and then you have other states that, so you have a real question of federalism here, which I think they're grappling with, but I don't think that the producer or the grower would have any liability for the transfer, but then obviously the person that they're transferring it, I think, would have liability, because you've got, the interstate commerce piece of it would not be criminal in and of itself because of the USDA opinion.
So the issue is, and the issue obviously with respect to the individual, whether the grower is also ultimately the person who's transporting it or selling it directly, or whether they're selling to somebody else, whoever's transporting it across state line or selling it on their website or whatever it happens to be. It's your understanding that that's under federal law that would be kosher under the 2018 Act. But it would still be subject to some sort of, see, that's what I'm trying to suss out here. Is that if I'm sending it to some place where it's illegal, right, and I'm doing it, I'm using interstate commerce in order to do that, and that act of putting it in the mail and sending it, or transporting it in a car and dropping it off, it seems like would be protected. And so at what point is there liability for a state to impose on that person who's selling the product?
Let me see if I can answer your question a little bit clearer. So you're asking at what point?
Clarity.
If it's,
the
so,
answer may be, I don't know, because that's where I end up on it. But go ahead.
so this much is clear. The transportation of hemp-derived products that are grown in accordance to a state program or the federal program is not prohibited. So liability just can't be on that fact alone, that it's being transported from a state that likes it to a state that doesn't like it. The other part of what you're contending with has to do with, well, what if a state has certain regulations? Well, I'm going to say it depends on what those regulations are. To the extent that the regulations are meant to frustrate or at least outright ban the possession or the transport of it, the 2018 Farm Bill is clear. You can't do that. Now, obviously, if it's, let's say a state has some sort of internal regulation that says, hey, in order for you to sell certain food products that have hemp in it or CBD in it, you need to have some sort of certificate within the state. I think, and your producer intentionally selling to that state, I think there could be some liability there. So it really depends on what the state's regulations are. And right now, we haven't seen any states do that or react to it. I anticipate much more reaction next year. Again, because by next year, all states are going to either have to have their own programs, or the U.S. Department of Agriculture would have a federal one that producers in states that don't have that program would have to subscribe to. Then what I anticipate happening is you're going to probably have a reaction from some states, either as it relates to derivative products. I don't think they could just target it generally, but so it would depend on what those regulations are. But in and of itself, transporting or moving products from one state to another isn't prohibited under the 2018 Farm Bill.
All right, I think we're out of time, so thank you. Thank you all for attending.